Thank you. Okay, and then do I share my screen?
Yes, go ahead. While Sasha is pulling that up, we actually had two guests come on board. We're asking everybody just to introduce themselves and what they do and why they're here. So James Torres, do you mind introducing yourself?
Hi, how you doing? Can you hear me?
Yes, we can.
Hi, I'm a commercial agent with KW Commercial over here in Downey.
Okay, thank you. Thanks for joining us.
Thank you.
Share, can you give me host access?
Marshall, can you make sure Sasha's co-host too? If Will can't. So one other thing that I just wanted to mention, because I know we do have a lot of realtors here. If you like the stuff that we do here at the Collective, you're always welcome to interview and join our family. We have the best commission rates because we have a cap. So basically, once you sell about 3.5 million in volume, you go to a 96% commission split. No monthly fees, no E&O every month, none of that kind of stuff. You just pay your basic fees towards those things when you close a deal. So it's a great structure, a lot of support. We value education and people who value education. So just by being on this call shows me a lot. So let's get into it. Miss Sasha.
Always slight hiccups with Zoom. Right there. That's me, yeah. There we go.
Do you want to stop sharing?
Yeah. I'll try to do it for you.
Sorry.
No worries. Thank you.
I'm sorry to interrupt. Cannot hear Sasha.
Can you hear me now?
Yes, thank you.
Okay. All right. So, per the little introduction, my name is Sasha Struthers. I am an attorney here in Los Angeles. My practice focuses predominantly on cash or keys or tenant buyout agreements. And I also do some government agency matters such as the CRD, or if you're in LA City, REAP, things like that, government agency compliance. But today we're going to talk about cash for keys. So just to begin, as a disclaimer, anything that we talk about today is just general information for informative purposes. It won't be tailored to any specific situation, and it is not going to be any legal advice or create any sort of attorney-client relationship. At the end, we will have a Q&A, so you guys can ask me your questions, and I'll do the best I can to give you some general advice or get you in the right direction. So kind of the outline of the presentation, it's going to be about 10-15 minutes. The most valuable part of it to me is the Q&A at the end. So we'll get through this stuff and we'll go over kind of basically what cash for keys is, what's the difference between a buyout versus relocation, when relocation is required, and why buyouts are popular, and then the different requirements for the different cities in LA. So to begin, cash for keys is very simply a tenant buyout agreement or voluntary lease termination agreement. It's when the tenant and the owner come to an agreement where the tenant will permanently vacate the unit and have no rights to come back to the unit in exchange for being paid. It gives basically both parties a chance to come up with an amicable resolution to, needing the unit back. It could be the tenant's really delinquent, could be the tenant's maybe a nuisance. Oftentimes in your situation, it's, you need the unit vacant for some sort of listing or investment purpose. So the point of the buyout is to try to bypass the eviction process. So buyout and relocation, they're kind of viewed just interchangeably. So a buyout is voluntary, whereas relocation is mandatory. However, why the two sometimes get conflated is typically there's certain rent control jurisdictions that have either a minimum requirement or have some sort of disclosure that outlines what relocation is. So it gives more or less tenants a guidepost on what they should aim to get in a buyout. Relocation is required typically when you have a no fault just cause eviction, which I believe we're going to go over in a second. Yeah. So no fault just cause, the tenant needs to move out for no fault of their own. So it has nothing to do with them either being a nuisance or not paying rent or violating the lease. It's just simply they're, having to move out. One of the most common ones is owner occupancy. However, it's very rare that a landlord needs to do a buyout for owner occupancy because there's rules for it. But they might, if they typically don't do an owner occupancy because they might not be staying in the unit that long. So they go, hey, maybe I have a job and I need to relocate to LA for 6 months, but the jurisdiction's going to require me to stay there for 2 years and I don't want to do that. So sometimes they'll do a buyout. There's also, depending on the jurisdiction you're in, some restrictions. Like for instance, LA City, if the tenants live there longer than 10 years and they're either disabled, terminally ill, or older than 62, the tenant can say, no, I don't want to move. So even if you're the owner, you won't be able to move into the unit. And then there's different kind of rules, depending on the unit size, what you need it for, who moved in last is the first one to go out. So it gets really convoluted trying to do an owner occupancy, especially if you're trying to target a specific unit. Approved condominium conversions, these happen, but they're really hard to do and take a long time, or sometimes don't get approved. Demolition would be another one. But demolition, you would do an LSAC, but depending on the jurisdiction, sometimes tenants have right of first refusal to rent back in the property once the development is done. So, you want to buy out to potentially avoid that. Removal of the property from the rental market. This is very rare and kind of a last resort, in my opinion, because if you LSAC'd it, because you have a tenant that's just paying really low rent, you really devalue the property, especially if it's a multi-family property. If you LSAC'd it, you have to LSAC the whole property, and then you can't rent it again. So you can't really LSAC, like a 16-unit apartment building, and not rent it unless you're doing that to demolish it, which again has strings attached. Government order requiring a unit to be vacated. Very rare that a government order will require that. You would think they would, but given kind of the politics, some government agencies will cite you and tell you to fix something, get it permitted, but they might not say the tenant has to move out. So that's kind of really up to whatever agency you're dealing with and maybe even the investigator. So again, very rare that that would come up. And substantial remodel. This one is getting a lot of pushback from a lot of different jurisdictions. I know Glendale was looking at getting rid of allowing substantial remodels. Some jurisdictions have it where you can't, relocate a tenant permanently for a substantial remodel. So you have to, basically temporarily house the tenant and then remodel this whole unit and bring the tenant back, and you get a very nominal rent increase for it. So a lot of landlords who are in rent controlled areas don't really look to the substantial remodel as a way to get out, because the tenants have the right to stay in the unit. So you just poured all this money into it and you're not going to get market rent. So why are buyouts popular? Because of all the sad news I just gave you a few seconds ago. No fault just cause reasons aren't always available to the landlord. If you have to go all the way through the process of going to court, it takes time. You don't collect rent money in court. It becomes very contentious. So buyouts are popular because it's a way to approach the tenant, have a one-on-one with them and, explain what's going on. I need the unit back. I'm going to be selling the property. We're going to be redeveloping it. And you're able to have a conversation with the tenant and, try to have a meeting of minds rather than, going through the eviction process. Excuse me. Yes. Are we going to get the slides then? Yeah, I can send them to Will and then Will can circulate them. And then my like, I think the most valuable thing of this whole presentation might be, or the second most valuable thing besides the Q&A, is the buyout chart. So with different jurisdictions, there's a bunch of different requirements. Some jurisdictions have minimums. I just bought out 8 units in Pasadena, and there was no minimum per Pasadena's Measure H and their rules. However, every tenant called housing and every tenant came back and said that they wanted relocation. So there's some jurisdictions that have minimums. LA County does, Culver City, Santa Monica, and Inglewood. And then some of them have really funky rules. Like LA County has a 45-day review period. So the tenant, you have to give them the agreement and they have 45 days to review it. You also have to file proofs of service with some of the agencies. LA City has a portal that you can upload to. As far as the agreement goes, all these jurisdictions have a disclosure. I should update this. Pasadena does now have the disclosure available. All of these jurisdictions have cancellation periods. So tenants have between 30 and 45 days, depending on where they're at, to change their mind. Some of the jurisdictions require the agreement to be bilingual. So the most common one in LA is Spanish. So if the tenant has ever spoken Spanish, or their primary language is Spanish, or you have a sense that they might speak Spanish, I make the agreement bilingual to avoid, not making that mark met. And then there's filing requirements for all of these jurisdictions. But the agreement, depending on the jurisdiction, there's specific language that has to be in the agreement, especially those that have the right to cancel, that has to be in there. There's some jurisdictions that have specific font sizes that you have to have the specific language in. It does get pretty technical. There's certain filing, like you can't file too early, you can't file too late. Like I know in Santa Monica, you have to wait to file it. And I think WeHo also, you have to wait to file after, I think like 30 days, and then you don't file if they've canceled it. So yes, that's basically the presentation. Go ahead.
I just have a question. I thought there were minimums in LA City.
No, so there's a buyout disclosure, and on it, it has the relocation chart. So you can buy out for less than that. There's rumor that they're going to make it permanent, like minimums for relocation. But right now, LA City, you could do less than that. It's very rare you would do less than that anyways. But like the most common times you would offer less than relocation is if the tenant has like a delinquency, or they have like a really hardcore nuisance that you've gone back and forth with them about, and you go, hey, you're not going to get that much because you caused all this damage or you've done all this stuff.
So those minimums are not required now, because I know it's like 11 or 12,000, I thought.
Yeah, so those are required for if you're doing a relocation, like by law, you had to pay them to move out. So the LA City chart shows, hey, this is what you would get in the event you were being relocated. Hint, hint. And if they call LAHD will tell them, no, try to get that. And Pasadena is the same. There's no minimum in the code, but they all call Pasadena, and then they all came back to me and they say, well, Pasadena says I have to get this. And you're like, okay, just fine. But it's like, that's okay, because that's kind of what you budget for.
Do these minimums change for 1 bedrooms and 2 bedrooms? I was always under the impression that there was a certain price for 1 bedroom, certain price for 2 bedrooms.
That's a good question. It depends on the jurisdiction. So LA County has it by bedroom. LA City doesn't. Pasadena has it by bedroom. I have to double check. I can't remember on the top of my head. Santa Monica does. I think you're right. But some of them have it by bedroom and some of them don't have it by bedrooms. Like LA City doesn't have it by bedroom size. They have it by years of tenancy, low income, and then if you're qualified, disabled, 62, or have minor children. But not everyone does it based on the unit size.
Well, as you can see, we've already started kind of the Q&A section. Sorry. So we're jumping ahead because we got a million. We have a lot of questions. I'm sure that the people are going to have. So I'm going to throw out a question. So we have a property triplex. Oh,
We can leave it on.
we can leave it on because I think people will probably be interested in, yeah. So, yeah, absolutely, that's perfect. For those of you who want to contact
I already
Sasha.
plugged on the page.
There we go.
I'll replug myself.
So, we have a subspecialty in converting multifamily to tenants in common. And so what's one of the things that we see in that conversion, a lot of people do try to, will basically consider Ellis Act because they're pretty much selling those for owner occupancy, right? However, like you mentioned, with the Ellis Act, there are specific things that come with that, right? And it means that the new owner wouldn't be able to rent it out, right? So could you go over a couple things? One, what are specifically the Ellis Act rules if you do decide to Ellis a building? Second of all, is it allowed to say, okay, to a tenant during a buyout negotiation, okay, we're planning to sell these as tenants in common. We were going to Ellis Act you, but if you would take a buyout, we would give you a little bit more. Would that be allowed?
Yes, so the Ellis Act, the Ellis Act is you're going out of the rental market or you're demolishing the building because you're going to be redeveloping it. So when you go out of the rental market, there's a 2-year, 5-year, and 10-year period. On the top of my head, I think in the first 2 years, there's a civil cause of action. The first 5 years, if you put it back on the market, then the tenant, I think, gets the unit back at the same rent with applicable rent increases. And I think 10 years, you're like kind of scot-free. So when you go to do buyouts, I tell tenants that. And a lot of the times when my approach is a little like more gentle. I'm not like at your door in your face, like take this money or like, you're going to crash and burn in eviction court. A lot of times I'm very frank with tenants. Tenants are not dumb. And I tell them, hey, my client is going to be doing this, this, or this. They're looking to owner occupy. They're looking to remodel the property. They're going to be selling it. And they're going to be selling it to an owner user or a developer. So at some point you'll have to move. So before we go through that process, we like to present you this opportunity to be bought out. And here's what relocation is. But we understand that, this is on a different timeline. Therefore, we'll give you more money. And we'll give you, usually it's like 60 and 90 days. And so you tell them that, like, hey, we plan to Ellis Act, which is things going to be coming off the market and you'll have to move anyways. So yeah, you can be honest about that. If you don't ever Ellis Act it, then you don't ever Ellis Act it. But a lot of tenants do get that. And they understand, they go, okay, they don't want to be dealing with either a new owner or like the unknown. So this is really a chance for them to go, okay, on my terms, I'm doing this. And a lot of the deals that I do, more and more I'm seeing tenants get it. Like, yeah, no, I get it. And tenants themselves, this money could help them. Sometimes they're like ready to relocate out of state, or they, maybe they're older and they want to live with family who's elsewhere. So this money is like an opportunity for them regardless. But yeah, I would tell tenants, if you're planning to Ellis Act, hey, this is what we're going to be doing. And we're going to do it, and our buyers are going to do it. So we'd like to give you this chance to come up with a deal on your own terms.
And the Ellis Act payments, are they the same as relocation payments in the city, or how are Ellis Act payments determined?
The Ellis Act payments are determined by the rent control board. If there's a rent control board, otherwise it would be state, 1 month relocation. But the Ellis Act, if there's a rent control board, typically it's tied to what that relocation is.
Very good. I am sure there are other questions. Please.
What you went through was for multifamily. How does it apply to single family or townhomes or condos?
I like this talking stick. So I've done increasingly more on single family residences because like LA City has it where you can't give a 30-day notice anymore. Santa Monica's the same, 30 or 60-day notice. You cannot. They said that we have just cause eviction restrictions now. So if you want your house back, you have to meet one of those just cause, which in a single family residence setting, is typically you're going to own or occupy. But if someone's going to own or occupy a house and they have financing, typically the bank goes, you need to be in there when you close it. So it can mess up the financing. So what a lot of landlords do before they list it, or, you know, sometimes buyers do it while it's listed because the landlord, you know, the seller doesn't want to deal with it, is they'll try to do a buyout of the tenant. And so I do a lot of those with tenants, and you know, they all come out with like crazy ideas. But for the single family residents, typically the relocation's lower, unless you're like in Santa Monica, or they just think like everyone is a gajillionaire. But those ones, you still do buyouts. And the reason being is it's just a little bit easier and you don't go through the eviction court. That's kind of, if you have a single family residence and it's tenant occupied, you could, in a jurisdiction where you're allowed to, give a 60-day notice. But sometimes landlords want to be kind of chill about it, especially if it's a longstanding tenant. So they'll go, hey, I'll give you a few bucks and we'll do a buyout agreement, and this money will help you relocate. And instead of giving you this 60-day, we'll do this. Or maybe you give them a 60-day notice and then you do a buyout agreement, because part of the buyout agreement typically is a general lease of claims where it's saying like, hey, you're not going to sue me afterwards. You don't have any issues. So, but they are very common with tenant occupied houses.
But you're saying it's not required to buy out?
It's not required to buy anybody out, but for a house, if you have a listing in LA City, let's say, and it's a house and it's tenant occupied, you can't tell the tenant to move. You can't give them a 60-day notice. You can't go, okay, I'm selling the house, you have to leave, because the tenants are protected. And it makes it very challenging for sellers because, again, people need to be in the house when they close, especially if they're financing, it's not a cash deal. So that's where a lot of the sellers, before they even go to market, will present to the tenant, hey, before I go to market and you start doing all these showings, or I do all these showings, and these people come in and these contractors, and these inspectors, and these buyers, I'd like to buy you out and give you a timeline to move, and here's how much I'm willing to pay you. And the tenants, by and large, get it. They go, okay. And a lot of tenants now almost expect that. It's very odd. Like they know a buyout offer is coming.
And is it any different for a condo or a townhouse?
No, it's the same thing for them. Condos though, like I know in LA City, there's some condos that are rent controlled. So like someone called me the other day about a condo because he wanted to buy it. And I looked it up. I go, this condo's rent controlled, by the way. He's like, oh, I didn't know that. So you want to be mindful of that if the condo falls under some sort of rent control.
RSO, is that?
Yeah, rank RSO. For LA City, Measure H for Pasadena. The other ones are just basically rent control.
Mostly in the San Fernando Valley, so what is that?
LA City.
Yeah.
San Fernando Valley, by and large, is LA City. Oh, talking stick.
I actually have two questions. The first question, along with the single family home. I just want to be clear on this. If tenants are in the home, or even multifamily, and the lease is coming to an end, and the seller wants to put the property up for sale at the end of the lease, can they give the 60-day notice? They cannot. And then I'll ask you my other question, which kind of goes, wow.
The lease beginning and end date for multifamily is a kind of elusive. Typically your lease agreement is 1 year. And once you lease your house, I mean, I'd have to like really dig through and see if there's like a technicality, but once you lease your house or your apartment, well, we're going to talk about multifamily. So we'll put houses aside. We'll talk about multifamily. There's state rent control. There's AB 1482, which gives tenants just cause protection. So you can't just end a lease anymore unless you meet one of those restrictions. So let's say every year you present your tenant with a new lease agreement, and next year you present them with the new lease agreement, the same thing, and they refuse to sign, maybe you could evict them. But trying to evict a tenant in like an LA court for that, I don't think would get you very far. So you can't just be like, okay, I want you gone. That's kind of what AB 1482 did. And then localities like Santa Monica, like LA City, went a step further and said, you can't get anybody out. If they're in there, you better have a reason to get them out, or you better buy them out.
So an investor I work with, he repeatedly when the lease ends, before the lease ends, and I believe he has an attorney write this, he purposely makes all his tenants sign new leases. He doesn't let them go month to month. But am I hearing right in when you say that it kind of doesn't matter? Like, even though you're doing that, it doesn't matter. It's the
Well,
same.
He's setting up a pattern. So what he's doing is what I just said. What he's doing is every year he's going through the task of you need to sign this lease, and the terms are probably exactly the same. And so you need to sign the new lease, or I'm going to evict you for refusing to sign the lease. And so if a tenant refuses to sign the lease and you go and evict them, that's technically a way you could evict somebody, but you're now in the eviction process, and now they're going to go get an eviction attorney, and now you're going to be in a jury trial. And then you'd have to compare the leases side by side and go, are they materially the same? Did you add a new provision? Was my unit not smoking restricted? Now all of a sudden I can't smoke it anymore. There's all these things. So side by side, they have to be the same. So what he's doing is he's doing that systematically. So one tenant refuses to sign, I think that's what he's banking on. That's what I'm assuming, that they'll not sign the renewal and he'll evict them. Sure. But if you have 100 units, 200 units, 1,000 units, and you're trying to like do lease renewals like that every year, like every landlord who does property management goes with a more realistic approach. It becomes a month to month. But multifamily landlords get that it's a game, and they single family, it's a little bit different. It could go month to month, or you could present a new lease and say, hey, sign it or move. But you're again in the same boat. If they don't sign it, you have to evict them. If you want to just end their lease, and depending on the jurisdiction, like LA City, you can't just end the lease. You can't just say, okay, get like GTFO. No. No. Depending on where it's at. It doesn't mean much. What the new lease is, you need to sign this and we're agreeing to it. And what I think he's doing is he's trying to go off the code that says if you refuse to sign a lease renewal for materially the same terms, then you could be evicted because you refuse to sign the lease. But again, there's a lot of reasons you could evict somebody, but whether you do evict them or you go through the court process and deal with it and prevail is a completely other thing.
Depending on the length of tenancy, does that equate to I will offer you more money for cash for keys? Is there like a vesting of some sort?
That depends. So if you're talking about like an apartment, you start at the relocation chart. Where does this person fall on the relocation chart? How old are they? How long have they been here? How many bedrooms, depending on what the relocation chart is for that jurisdiction. So you kind of go there. Now, there's a drastic difference between relocation as scheduled by this, the jurisdiction, and what the tenant will agree to accept. So if you have a tenant who's been in an apartment for 25 years and they're paying $400, you can offer them relocation and they might take it. Or they might go, no, I want like $150,000. So you never really know until you ask the tenant. You have no idea. I've had tenants that have lived in units for a very long time, paying very low rent, take relocation to move out and made no fuss about it. I've had tenants who pay really low rent, live there for a very long time, are protected, and took $75,000 to move out. And I've had it, all in between there. So what you would offer and what you would end up paying, it moves. It's like a sliding scale. There's averages like Santa Monica, West Hollywood, and LA City. They post the average buyout. Santa Monica is really good about aggregating the data. You could go to Santa Monica's website and you could see what address, what size it was, and how much it got bought out for when. So they have the data. LA City, Kenneth Mejia said, hey, buyouts are averaging $25,000. So they have the data for it. But that's an average. There's going to be an outlier where a tenant really doesn't want to go. And there's going to be the outlier where the tenant's like totally chill, like where do I sign? I'm ready to go. And I get those more often than I think I would get them. But yeah, it varies.
We have a Zoom question. Donna, do you mind clarifying what you're asking here? Do you mind?
Well, I'm just wondering, I have 3 on a lot in Silver Lake. And so if relocation is like 25 grand for this lady, she's been there over 15 years. Can I offer that, or she can just say, no, that's not enough, and then I have to pay her more?
So with the buyout, you can, depending on where you're at, offer, either relocation as the minimum or above it. So if let's say you're in LA City, you would go, when I do a buyout offer, I present the offer to the tenant and I give them the applicable disclosure. I don't hide it from them. And the disclosure says typically on the chart or on the disclosure what the relocation chart is, or it tells them contact housing and we'll talk to you about it, get information. So if you have an LA City apartment RSO unit and you want to buy her out, you would figure out where she's on the chart, the 24 650. So you could start there and say, hey, I'll pay you 25,000. I'll give you 60 days to move out. And she might look at the chart and go, okay. And a lot of tenants look at it, and there's tenants where I offer them less than the chart. Like I did one the other day and I offered the couple 15 grand, but they had owed 16 grand in rent. And then they disputed it and said, no, we don't owe that, but we want what's on the chart. So my client goes, okay, I'll pay what's on the chart then.
Right. Well, okay, so I can start at a lower number. I'm not required to start at the top number. Is that right?
Where's your building at?
Silver Lake.
LA
It's
City?
3 on a lot.
Yeah.
Yes.
So yeah, you could offer less.
Okay.
But
now, if I offer her, I'll give you like 15,000 and 6 months to move out. Just to help her, because I want to rehab them, and I've offered her a vacant unit to live in while I rehab hers, and I don't think she's going to go for that. My other tenant is willing to do that. He's willing to move to the rehab unit while I rehab his,
but you're going to bring him, are you going to bring him back to his unit?
Well, I would leave that up to him. If he, what I asked him,
did you sign a new lease with him for the unit he's now temporarily? Okay, so
they're
that's
all month to month.
Okay, so you're kind of setting yourself up to fail from what I'm looking at.
Oh,
if you temporarily move him to another unit and you rehab his unit, you're not going to get market rent. Now,
but today I spoke to him and I asked him, would you agree to pay $400 more a month? And he said, yes.
He cannot by law agree to that in LA City. What's going to happen is he'll pay it and he'll go to housing, and housing will say this is an illegal rent increase and you'll have to pay him all the money back. My client paid $40,000 back in rent because he did that. So you're now remodeling his unit and you're going to be getting the same rent back plus an applicable rent increase as determined by the city, either for primary renovation or capital improvement. So you essentially just remodeled the unit for the same rent. You can pass through up to $55 a month for a capital improvement, all new plumbing, all new electrical, new roof. But
it's just not worth it.
No, so you'd have to buy him out. But he temporarily staying there, you just temporarily moved him to a unit, but he will come back, and even if he agrees to the 400, he could always go to housing, and then housing will tell you that's an illegal rent increase. You have to pay all the money.
Okay. So I need to offer both of them.
You would want to offer both of them a buyout. Now you could tell him you could enter a lease for the unit that you rehab and he's staying in. Say, hey, you can stay here, but you have to enter a new lease. But you've already kind of put him in there. So you're in an awkward position of now he knows his unit's going to be remodeled. And now you're going to want market rent for the temporary unit. So it's possible.
So if I rehabbed the vacant unit and he agreed to move there at a new address with the higher rent, that would be acceptable?
That's a whole new lease. It's not a unit. If
Okay.
it's not a unit he's living in or was living in,
Right.
then yeah, he could sign a lease and go, hey, you're going to move into the brand new remodeled vacant unit for market rent. Yeah, because it's a
Okay. Oh,
brand new
good.
lease for a brand new location. But if you're remodeling his unit and then you temporarily put him in another one and he's going to come back to his old unit, you're at market rent plus whatever pass-throughs the city allows.
Okay. So I guess the deal would be rehab the empty unit, ask him if he wants to move there at an increased rent,
At
and
the
then
market
leave
rent,
him
yeah.
there.
And
Leave
then
him there
put
if he
him,
accepts it.
yeah, and then put him in that unit, and then you have a new lease, and then you would rehab, I guess, whatever unit he's in. But
Right.
yeah, you don't, a tenant, and I get asked this all the time. In rent control jurisdictions, which virtually almost everything in California is rent controlled to some degree or not, the tenant cannot agree to a higher rent increase than what is allowed by law. They just
Okay.
can't do it.
Well, that's very helpful. Thank you.
And that's why we have these. Okay. Are there
It's so
any?
complicated.
It is complicated. Like I said, that's why we do these.
Oh,
Anyone
and
else on
also,
Zoom?
Yes,
go ahead.
I have
Dawn.
another question. Sasha, are you available for hire to negotiate this?
Yes.
Okay.
Yes, I do it two different ways. I negotiate it on behalf of landlords, or sometimes landlords do it themselves because it probably have a long-term relationship with the tenant, or the real estate agent, quite frankly, does a lot of these deals, and then they just bring it to me and I draft it. But if you go to my website, I have a contact form, like a contact page. Fill out that form and I'll reach out to you.
Okay. Thank you.
Thank you, Donna.
Thank you.
No, I charge a flat fee. So for drafting the agreement, and I don't do any of the negotiating, it's a flat 1,500. If I do the negotiating beginning and end, it's 3,500. So it's 500 up front, and then 1,500 when the tenant signs, then 1,500 when they move out per unit.
Any other questions? I think that's enough for
This
you,
is so
Sasha.
wonderful.
I mean, this is why we do this, right? We do this because we like to provide education. You know, last time we had Niv Davidovich on landlord-tenant law. We've had talks on 1031 exchanges. We've had talks on, you know, everything regarding multifamily that you can think of. We try to cover those topics. And if there's any other topics that you want us to cover, let us know, and we will see if we can get we'll get a speaker for it. So let's thank Sasha again for all the wonderful information. I'll let Anthony close it out, and you're welcome to stay online and network for a bit.
All right. Yeah. Thank you so much, Sasha. And thank you, Will, for all the work you do in finding us some of the best speakers. Thanks for joining us. We'll see you guys at our next session. Our website is lamultifamilymeetup.com. Feel free to share that with any of your friends or clients or other realtors. That'll take you to our meetup page, so you will be guaranteed to get notified of any of the meetup sessions that we do regarding multifamily. And then also check out thecollectiverealty.com. We have other events and other classes and stuff that we'll list on there, and we'll keep you informed of anything happening in this crazy real estate market. So have a great week, everybody. Happy Father's Day to any fathers who are out there. Special holiday this weekend. Yeah. And have a great summer. We'll see you soon. Thanks.
No, she's actually. Yeah, before you meet me,
She has 3 houses